Welcome to San Antonio Injury and Employment Law Podcast.
Welcome to the San Antonio Injury and Employment Podcast with Trey Cammack, founder of Cammack Law, PLLC. Trey is a personal injury attorney based in San Antonio who helps individuals and families navigate serious injury cases with clear, practical approaches. I'm Evan Mack, and today we're focusing on one question that causes a lot of confusion after an accident. What happens if you think you may have been partly at fault, how Texas handles shared responsibility, and why those situations are not always straightforward as people assume. Trey, my man, welcome back.
Evan, always good to see you.
Good to see you too, brother. So this is interesting, but people sometimes assume that if they were partly responsible for an accident, they automatically don't have a case. How does Texas actually handle a shared fault case?
Yeah, so there's a comparative negligence element in Texas. The Civil Practice and Remedies Codes has a statute related to that. So if you are deemed by a jury and the jury ends up deciding to be 51% or greater or the majority at fault, it is correct that you do not have a case. You will not be able to collect any money. But there's also a chance that you have your verdict reduced. So if you're 50% or less, then you can get a reduction. So for instance, if I get $100,000 settlement, but I'm found to be 30,000% at fault, then I really get 70,000 of that because that 30% is a portion of as fault against me. But assuming what a jury will or will not do, there's a lot of ways to find that information out and develop the evidence to determine, who's at fault and who's not at fault through the development of the case.
But what kinds of situations tend to create these disputes? You kind of said it, but is it who was at fault in the first place, or is there something else?
I would say there may be the colloquial swearing match at the red light. A lot of times stop sign, red light, you're going to have people say the other person did it. And sometimes you're not going to have the evidence for that. Not all the cameras that are set up in the city or in cities are going to be ones that function in the capacity that are actually recording whether wrecks happen occur. And then you're going to have sometimes when people turn left lane or right lane in certain types of turns in front of people, those are going to be ones as far as in vehicles. Stuff at work often happens, or on premises liabilities a lot. You're going to have arguments over fault.
Who decides how much fault each person carries? How can that change as the case moves forward, though?
Ultimately, that'll be up for the jury if it's selected for a jury demand in the state of Texas. But, it can develop through a lot of time. You have a car wreck, police show up, police give a report. The police, generally speaking, will say if they find someone's at fault or not, if they can figure it out. Now, sometimes what they do is they have a numbering system. So they'll say this number means this person was following too close. This number means they were distracted with driving. This number means whatever. It's attributed on the Texas crash code sheets. And so they may attribute it to both sides. They may attribute it to just one. There may be multiple vehicles in the car wreck. So early on, getting pictures of the wreck, photos of the vehicle, physical evidence from the vehicles themselves or from the scene of the wreck, and getting eyewitnesses, in addition to that police report, are really helpful in determining who could or couldn't be at fault.
So what does Texas's 51% rule mean in, just simple plain English for the layperson, for someone who may share blame for an accident?
Well, what it means is if a jury rules against you 51%, then you're out of luck, unfortunately. But if someone's not sure, they should at least evaluate, particularly if they have serious injuries. There's a possibility they can evaluate and there is evidence that would demonstrate otherwise. I've had cases where it looks like, it was clearly a swearing match at the light or swearing match at the stop sign. And I will say they are harder to prove if you don't have specific evidence developed pretty early on. So it's important for people to get that evidence day of, scene of the wreck. And that's not often what we're thinking about. We're thinking about, is everyone okay? But making sure you have that evidence to be able to submit to your insurance company, to your attorney, is very important early on.
How do these insurance companies try to shift blame onto the injured person, even when the other side clearly played a major role in the accident?
That phone call, they get that phone call with you. They want to hear, hey, what did you say at the scene? What did they say at the scene? I said, well, I'm sorry. Hey, maybe I wasn't looking the right way. Hey, maybe I was going too fast. There's certain levels of statements at the scene that can be hearsay or can be exceptions to hearsay that could be related to fault or coming in, or related to sympathy statements, or related to, offers to pay medical. There's all these different exceptions to evidence under state and federal rules. And there's some under the Civil Practice and Remedies Codes of Texas that also govern, but they definitely want to hear you saying something like, hey, look, no, I wasn't bleeding at the wreck. I didn't think anyone was hurt. I don't think I was hurt at the wreck. Everyone said they were okay. I'm okay. So making sure that you know that you don't have to give them a statement is always important, but getting an eyewitness is helpful, particularly if you have a credible one, in addition to any of the actual evidence, because the insurance companies will value those sometimes.
what details about the accident itself tend to matter the most when people disagree about, who caused it, Trey?
I would say if you have an issue with the police report as drafted, let's say you say, hey, I know that this isn't correct. For instance, I've seen a wreck where I had a case that was assigned. No one wanted it. It said that our client rear-ended a vehicle. Well, why would you want that case? But I looked at the evidence of the vehicle. There were lug nut cuts on the side of the front of my client's vehicle, meaning he was sideswiped when the lane ended. And so what I think had happened is there was a rainstorm where the police officer responded to the wreck, heard the first driver's version, and decided, I'm not standing out here in the rain, and I'm going to go ahead and write down they're rear-ended. And so they may not even seen from their box truck, may have thought they were rear-ended because they were coming over and hitting them. But that evidence of the property damage on their vehicle was a really good example that actually helped make the case a very valuable case. Now, in the alternative, I had a swearing match at a stop sign where they had a car going their way, said they saw the light turn green. We had a car going our way, said the light turning green. However, their witness worked for NASA, and our witness was actually an actual crackhead who had been looking for crack within 48 hours of that wreck. So you could imagine that the jury decided that the employee of NASA was a more credible witness, and we lost that one. So finding out early what your evidence is and the credibility of your witnesses is very, very important, as opposed to determining that a couple months before trial.
Yeah, it's kind of hard to argue with a NASA witness, I suppose.
Yes, it was.
My gosh, does partial fault only affect these car accidents, or does it show up in, other injury cases as well, though, Trey?
I think it's going to impact greatly premises cases. There's a lot of back and forth on premises cases where the landowner, for instance, will say, if this is an open and obvious condition, we're not at fault unless there's a necessary use or unless it's this necessarily dangerous condition, and very much so in workplace injuries. So Texas is the only state where you can be a non-subscriber to workers' comp. And so what that means is every other state, you have to have workers' comp insurance. In Texas, you have a choice not to be as an employer. For instance, Walmart, one of the largest employers in the country, is not a subscriber in Texas. But if you don't have that workers' comp coverage for your injured employees, you can no longer argue comparative fault against your employees if they're hurt. So, that's a risk that they take. They also take a risk, of course, of being sued for negligence as a result, or under some other, provision if they have different types of plans. So I think in workplace injuries, it shows up the most as the type of cases outside of car wreck cases.
So how can something, a person, what they say at the scene, especially an apology or that assumption that, that they caused the accident, create problems later for them?
I think that your instinct at a wreck will always be to check on yourself, people in the vehicle, the other vehicle. That's just should be your instinct, right? Make sure everyone's okay, make sure the vehicle's not on fire, make sure you don't have broken bones, get the vehicle to the side of the road. But often our instinct is also to say, are you okay? And because I'm not bleeding from my head, or because I'm not dragging my leg behind me, to say yes. And so that's not necessarily a problem. But when people start saying, hey, I'm sorry. Hey, look, here's $200. Let's take care of this. Some of those things can or can't be admissible. There's a lot of different nuances in hearsay. I kind of touched on that a little bit, or what exceptions or exemptions to hearsay on. But I think when people give sympathetic statements to, I'm sorry, I hope you're okay, that's not necessarily going to be able to be used against them for liability. But people should be wary what they say. People are really just kind of being in survival mode in that beginning. And, human decency should kick in where we're all just making sure we're okay. Later on, when insurance companies start talking about premiums and the cost for a rental car, and then medical bills start piling up, people don't always necessarily become as friendly anymore when now I'm missing time for work. Now my insurance company wants some type of payment. And so stories kind of may change when people are concerned about some of that. So it's important really to watch what you say. Make sure, obviously follow the humanistic element and take care of people, make sure they're okay, but limit your statements as far as anything related to liability, being at fault, or paying for things.
So, Trey, if someone thinks they might have played a role in an accident, what would you want them to understand before deciding they don't have a case?
I think be realistic with yourself, right? If you ran a red light, maybe don't call a lawyer. I mean, if you ran that stop sign, but if you're like, hey, wait a minute, my light turned green, I went through. Or I think importantly in a lot of those cases, when two vehicles going the same way are hit by another vehicle, that's pretty strong evidence that it's unlikely statistically that those vehicles both ran the red light at the same time as opposed to the other driver. So just kind of looking at what actually happened, what was the scene, were you in fact paying attention the way you should have been? You know, if you're going to call me and tell me, hey, yeah, I'm pretty sure the light was green, but I was looking at my phone, I'm not going to help you with your case, unfortunately. And you know, so being realistic about what happened, but also that's part of being a safe driver. Get out there, be a defensive driver, text them when you get there. You know, I don't work for TxDOT, but seriously, like, you know, you should be careful on the road. It is dangerous. It is, people switch lanes all the time. Texas has very fast roads. Be aware of your surroundings, but then if you do get in an accident, you know, be realistic. What happened? You're rear-ended? Well, that's probably the other driver's fault. You know, did they pull out of a private drive and hit you? That's probably the other driver's fault. Did they do a U-turn into you? That's probably their fault. So get a realistic assessment and get the evidence early.
That's good stuff, Trey. Thank you for your time, brother.
Thank you. Always good to talk to you.
Right. That's it for today's episode of the San Antonio Injury Employment Law Podcast with Trey Cammack. If you'd like to learn more about Trey Cammack and Cammack Law PLLC, visit CammackLawPLLC.com. You'll find information about personal injury cases, what to expect during the legal process, and resources designed to help Texans make informed decisions after a serious injury. Thank you so much for listening, and we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.